Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information at your own risk. All right, after this very important disclaimer, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam, and we are live on YouTube, also on Twitter, known as X. So do follow us on different platforms like Twitter, LinkedIn, Facebook, and also on Instagram as well. And don't forget to like, share, and subscribe to Immigration Talk Show. And talking about today's topic again, friends, it's very important and very serious too. That is, lost your job on H1B, some smart ways to bounce back. So recently, we got this news where H1B visa holders have been laid off from tech giants. And I know it feels so sad, it feels so overwhelming. But trust me, it's not the end of the road. You still have 60-day grace period, and you never know, maybe these 60-day grace period can bring some more opportunities than what you think. You just have to make sure that you have full information of everything that's happening right now. And for that, you have to subscribe to our channel at Immigration Talk Show and also must watch this session. Because in this webinar, we are going to unpack so many insights and so many great information about today's topic. And to help me out, make this session a wonderful one, very insightful one, none other than attorney Poonam Gupta, who has over 25 years of experience in immigration law, plus a solid background in intellectual property and litigation, who will be providing knowledge on the topic. So, hi Poonam, and thank you so much for joining us back again. I know it's been quite a long time. So, welcome back to Immigration Talk Show.
Hi, Sam. Great to be back. And it's a great topic that's near and dear to a lot of immigrants. And I'm happy to be here to help provide some clarity to some of the issues that are common across the board.
Absolutely. It is really a very high time right now, especially for H1B visa holders. And I'm sure so many viewers, who are watching us have already have so many queries and questions regarding the topic. So friends, go ahead, post your questions, your queries on the comment section. We are here live for an hour with attorney Poonam Gupta, and we will be taking back again your questions after half an hour. So go ahead, post your questions, be more vocal about it, and sure, we are going to provide some expert advice to it. Okay, so Poonam, before diving into the topic, if you can just give a sneak peek what our viewers should expect from today's webinar.
So, the goal for today's webinar is to help people understand some of the critical things they need to keep in mind once they lose their job, whether they're on H1B, L1, TN, O1, E1, E2, E3, it doesn't matter. If you are on a work visa, then you have the benefit of potentially up to a 60-day grace period. It's most people assume it is 60 days flat out, regardless of whatever your situation may be, but that's not true, and we'll dive into why. Also, how it impacts the dependents, their work authorization, your status, your ability to switch to different statuses, go to another employer, and so on. So there's a lot to unpack, and let's get to it, Sam.
Wonderful. Okay, so I'm really excited for the session. And friends, don't be sad, don't be hopeless, be resilient and be hopeful because this session is really going to bring a lot of information to you. So I think let's begin with my very first question, Poonam, that I have for you. And that is what are the first steps someone should take after losing their job on an H1B visa?
Um, and this is the question is posed as an H-1B, but I want to clarify that this applies across the board. Anyone on a work visa should do two things. One, determine the last date of employment. It could be the day you were terminated and told your employment ends today, or it could be we're giving you advance notice and your employment will end in 3 months from now. The last date of employment is not the day you were told, it is the day you were paid, the last day for which you are paid. Look at your last paycheck, look at and determine the exact date. Next, look at your I 94. When does your I 94 expire? If your I 94 expires within the next 60 days, then you do not have a full 60-day grace period. The limitation in law is people are eligible for a grace period of up to 60 days or the end date of the I 94, whichever is shorter. So if your I 94 ends before the end of 60 days, after your employment terminates, then that date when your I 94 ends is your end date. And that is the date you need to plan for. So if your I 94 is expiring a week after you're terminated, that's it. That is the your end date. You only have a week to get everything sorted and put together. So these are the two things that are absolutely critical before doing anything else. And if you need help figuring out what that clock is and whatever, please reach out to an immigration attorney who can help you determine, looking at, ask you all the questions and help you determine what is your exact potential grace period. And one other thing to keep in mind, this is a discretion. The grace period is a discretion that the US government can choose to give to you. They can, so far, we've never heard of a case where USCIS has not exercised this discretion, but it is important to remember that nonetheless, it is a discretion and it is something we have to proactively ask the government to give us, to our clients. And then once you've determined what your end date is, what is the end period for your grace period, then figure out what your options are. Do you have another job lined up, or will you have another job lined up before your grace period ends? Are you able to switch to another status before your grace period ends? Um, and so on. And that switching to another status tackle in, further later down, but it is not just B2. There are considerations and concerns with switching to B2, but that seems to be the default that everyone's like, can I switch to B2? Like, there may be better options. So either figure that out yourself or work with an attorney to figure out what those options are. Don't just assume that B2 is the best option. In a lot of situations, it is not an option.
All right, that's wonderful. And thank you so much, Poonam, for taking that question up and explaining us, that very important information in a very detailed manner. And friends, I think it's really a very difficult time for you guys. So it is really best advice to go ahead and look out for attorney. And instead of looking for here and there, it is like a great thing to go ahead and get in touch with attorney Poonam Gupta. The link that is visible on the screen, you just have to visit that link and you will get the contact details of attorney Poonam Gupta. So that will be the great thing. And go ahead, ask any questions. Yeah, this link is here. You just have to visit this link and you'll get the contact details. Okay, and with that, Poonam, let's go ahead with my next question. And this is regarding how much time do H1B holders have to find a new job after a layoff? And also, what are their options during that grace period?
As I mentioned, H-1B holders and other visa holders may have up to 60 days of grace period, assuming that that person has a 60-day grace period. then they have the full 60 days to find a job as long as the new employer files a petition for their benefit before the end of that grace period. Sometimes, as I mentioned previously, the period can be less if the I 94 ends earlier. So please be mindful of that. Moving to what are the options for switching to status and what can a person do? A person can legally stay in the US, but they cannot work. A person can look for a job in the US during this time, and if they are in H1B status, as soon as that employer files that petition, they can start working for that employer. If the individual is in L1 status, they could, and it's a large corporation with multiple entities, they could potentially move to another entity which is covered on the same blanket. If there is a role within the same organization, they could absolutely move to another role within the same organization for an L1. For individuals in other statuses, TN, E1, E2, E3s, or O1s, it depends on the specific circumstance, but most instances they can switch to other employers.
All right.
There's always the option also, if applicable, to switch to a dependent status. So you may have your own H1B and your spouse may have their own H1B. And sometimes it's preferable to switch to being an H4 dependent over a B2. And in my view, a B2, switching to B2 status should be the last resort when you have absolutely no other status to switch to. If you have the ability to switch to a dependent status, then that is the first preference. You can also switch to an F1 status or potentially apply for an O1 yourself, or if you have your things lined up and if you're entrepreneurial and want to start your own startup and sponsor yourself through that H1, that may also be a possibility. But again, it depends on a lot of things and very fact specific to your situation. So it's important to work with an attorney to figure out at least what your options are and then take it from there. And if you're not able to action, if you're not able to switch to any status for whatever reason before the end of your grace period, whether it's 60 days or less, please plan to leave the US before the end of the grace period to avoid accruing unlawful presence. Unlawful presence can have a lot of downstream negative impacts on your immigration journey in the United States, not only immediately, but potentially for the rest of your life. So please avoid accruing any unlawful presence. And I'm using a technical term here, but unlawful presence is when you have no status in the United States. So while you're in the grace period, you have no status, but you're authorized to stay in the US. But once the grace period ends, or if your change of status petition is denied, that is when you start accruing unlawful presence. If you stay in the US for 6 months, up to 6 months, without having any status, then you can be barred from the US for up 3 years, coming back to the US for 3 years. And if you stay in the US for up a year without having a status, then you could potentially be subject to a 10-year bar from coming back to the US. So it is not likely that I make the suggestion to not go in that territory, especially in this environment under this administration. It is absolutely critical that you are mindful of your status and maintain your status at all times. So that is my guidance for now, but there are lots of other nuances to it that are very fact specific, and happy to go into them if
Sure, I
there's.
mean, why not? We would love to.
Yeah, I mean, time permitting, we can come back to those, but because it's very fact specific, right? Someone could be on H1B and they have a spouse that is also on H1B, but that spouse doesn't have an I-140 approved, for instance. Then they can switch to H4 but can't apply for H4 EAD. But if the spouse has an I-140 approved, then they can apply for EAD and switch to H4 as well. But the timing may not work. So it's very, very fact specific. And we can take those fact specific questions as we are further down after we've addressed some of the more high level questions, if you will.
All right, that will be great. I think that will be little easier for our people to understand.
Of
And
course.
absolutely, Poonam, that's very well explained everything, and that too, it's a really difficult time. That too, looking at the scenario, it's quite uncertain. So, friends, it's better advice to follow all the instruction that Attorney Poonam is saying, suggesting right now. That is the best way to leave the USA before the grace period. Or if you're thinking it's not the right time, then it's better to get suggestion, get some help from the attorney. Okay, and Poonam, as you were mentioning about dependents, so I think let me go ahead with my next question related to that only. Do the dependents benefit from the 60-day grace period? What's your answer to
Yes.
that?
Yes, always. Whatever status and whatever um, benefit the principal or the H1B holder or the L1 or TN or O1 holder has, their dependents have the same benefit. So if the H1B holder is eligible for a 60-day grace period, their dependents are also eligible for the 60-day grace period.
Wow, that's great. Okay, and let's move ahead with my next question. And this is again a very demanding question, Poonam, that most of our viewers have been posting. That what if someone who is living outside the US when the employment is terminated? Sorry, not living, but been outside the US for some time, but unfortunately he got the news that his employment is terminated. So, what to do at that time? What suggestion would you like to give to that person?
So again, depending on what the details. So if someone is terminated effective immediately and they are physically outside the US, then they have no grace period because they no longer have an I-94, which they can use to determine the grace period. Um, and but if someone is notified that your employment will be terminated 3 months from now and they're physically outside the US at that time, then they should plan to come back to the US as soon as possible so that they can benefit from that grace period and stay in the US during that grace period to find alternative visa statuses to apply to, whether it is changing employers or switching to another status.
All right. Okay. I hope, friends, you are getting these information and noting down all the pointers that is being explained over here, because these are very minute details, Poonam, that we are not able to explain in 2 or 3 minutes video. So that is why we have these 1 hour live session with experts like you, so that our viewers get a lot of benefit from these webinars. So thank you so much for your answer. I'm really, getting a lot of things to learn in today's webinar. And let me go ahead with my next question. That does USCIS need to approve the transfer before the person can start working again?
It depends on the person's status.
Okay.
If they are in H1B status, then yes. And sorry, I'm going to clarify. If they are in H1B status and they're still within the grace period, then yes, they can start working for the new employer immediately upon filing of that H1B petition because of H1B portability rules. But if someone is in another status, say L1, O1, TN, E1, E2, E3, then they have to wait for the approval before they can start working. So this benefit of being of the ability to work for a new employer during the grace period is only applicable for H-1B holders, no one else.
All right. Okay. And with that, I also want to greet our viewers because we do have lots of comments from some of our viewers. Ailey, I can see Alicia, Ricky is also here. So thank you guys for posting your questions. Stay tuned. Soon we are going to take up these questions and make sure if you haven't subscribed to our channel yet, do it right now. It takes even less than a minute. Okay, let me go ahead with the next question. And this is again a very important one. Then, what if the new employer delays filing? So, can it still count as timely if within 60 days grace period?
If it is filed within the 60-day, within the grace period, whether it's 60 days or whatever the grace period may be, if it is filed before the end of the grace period, then yes, it is timely, and the person is authorized to stay in the US until that petition, there's a decision on that petition. If it's approved, then there will be no gap in authorization or their status. It's as if they were always in their status, whatever that status may be.
Okay.
If the petition is denied, then from that day onwards, they have to plan to leave the US immediately. And they start accruing unlawful presence from the next day. So it is critical to not only have the employers file the change of employer petitions as soon as possible, but also to be mindful of the decision on that petition, because if it is anything but an approval, it could potentially impact the person's status. So we want to be mindful of both of them.
Absolutely. All right. And also talking about, risk of traveling. Of course, you have mentioned about traveling right now. But Poonam, what are the risk of traveling internationally when someone is during the grace period after losing a job?
There is no potential to travel internationally. If someone is in a grace period and they leave the US, that is the end of their grace period. They cannot come back.
Okay.
They can only come back if they have a valid purpose to come back. So if they're coming back to study, then they need a valid F1 visa to come back, and I-20 and everything that goes with it. If they're coming back to work for another employer, then they need a valid approved petition from that employer.
Mhm.
If they have a valid visa, then they can reuse that visa with the new approval notice. But if their visa has expired, then they will also need a new visa. So again, depends on the facts, depends on the situations. But once a person travels outside the US, that is the end of the grace period.
All
There
right.
is no coming back.
That's sad, but that's how it is. And Poonam, here's another question that a few days back, some of our viewers have been asking because they have been laid off while on H1B. So they were asking for their future, hiring companies. Are they going to view it as a negative one, or how they are going to view it as?
So I think if there was any stigma attached to layoffs, if there ever was,
Mhm.
it definitely has dissipated since 2022, when the massive layoffs began, and they haven't really stopped. In the
Mhm.
last 3 years, there have been hundreds of thousands of layoffs. Previously, with the perception maybe if someone is let go, it must be for performance, and that is where the stigma is attached.
Mhm.
But given the volume of layoffs in the last few years, most of which are for economic reasons that have nothing to do with performance, most companies, in my view, are if they have a need, they are eager to hire talented individuals on that. I mean, even if they are on visas, they are happy to hire someone. And I have not perceived any negative connotation associated with a previous layoff, just because that is the market, that is the industry, like regardless of industry for that matter. Every industry has experienced layoffs of immense levels and disproportionate to what has ever been seen before.
Mhm.
So, in my view, there is no negative perception by future companies. And I just want to add one more thing about timely filing of H1Bs before the end of, like, if the employer's delay or whatever,
Mhm.
before the grace period. In
Yeah.
my experience, most employers, if they are sophisticated um, and familiar with immigration, then they are very sensitive to the grace period and are timely and do everything they can to timely file the H1B petitions or whatever petition they are sponsoring the individuals for. The concern about timely filing only comes when the company is using someone or hiring someone on a visa for the very first time. That is when that education learning curve about immigration is really steep. And
Mhm.
that is the only situation where I have seen employers unintentionally delay filing the petitions. But as soon as they're educated, they get on board and are mindful and super cooperative about rushing through the timelines to make sure that the deadline is not missed and the person's visa or application is filed well before the grace period end date.
That's right. Really insightful, because these are the pointers, it mostly depends upon the companies as well. There's no yes or no answer, how they're going to view it. But
Correct.
absolutely, I hope, Poonam, most of our viewers would have the same thinking and really need to have these things in their mind. Okay, also,
As,
talking about, yeah, yeah,
as
sure,
I'm just going to add a little bit to that.
sure.
As immigrants, because it is your status, you have to take the lead role and take charge to educate an employer that is not familiar with immigration, whether it is sending them links from the USCIS website
Mhm.
or um, any materials that an attorney puts out. Those are ideally only USCIS materials because those are the most authentic and accurate sources of information. I would not recommend ever sharing any forums or any other information unless it is specifically tailored by an attorney for you. Other than that, I would only recommend sharing and educating prospective employers about the
Mhm.
need for speed by using USCIS guidelines. And there is USCIS actually has a dedicated page for individuals who've been terminated, and they updated it, I believe, January of this year, the last time I checked. And they have a wealth of information that cover a lot of questions that we may not be able to get to here. So please do check out that resource as well. Um,
Absolutely.
and coming to this question, dependent spouse EAD, yes. If someone is on H4 EAD or L2 EAD or E2 EAD or any other kind of EAD as a dependent, that EAD remains valid during the grace period.
Hmm.
But as soon as the grace period ends, that EAD ends, and whatever status the principal changes to, the dependent should change to that status as well.
All right.
So if someone is on H1 and they lose their job and their spouse has H4 and H4 EAD, if they are switching to B2, please remember to switch your spouse and the kid's status to B2 as well. They cannot remain on H4 if you don't remain on H1B. So a lot of times people only think of their status and forget about their dependent status unintentionally. But so this is a call out and a reminder to please remember to do that as well. Your dependent status is derived from your status. So be mindful.
Wow. That was a very important one, Poonam, and thank you so much for putting that up because, of course, I mean that's a great one. So many people just forget and they just look upon their status, not of their dependence. So I hope, friends, by these insights, you may feel more full information and will take steps accordingly. Okay, here's another question, Poonam, for you. That what if someone who missed the 60-day grace period deadline for switching to another status? So can they still apply for a change of status?
Potentially.
Okay.
As I said before, the 60-day grace period, whatever that grace period deadline is, it is sacrosanct and it's something that you need to be extremely sensitive about. This is not something to take lightly because
Yeah.
if you miss this deadline, there is a potential that you may be out of status and that may impact your journey in the US down the road for years to come. You could be barred from coming to the US as an extreme measure, so you do not want to forget about this deadline. And a lot of times there are situations where it is outside your control and you miss the deadline because and I've had this happen where someone was in the hospital and they were physically unable to do it. I've had situations where a person was having a mental breakdown
Okay.
and were unable to function in any way. And by the time they worked with their therapist and their psychologist and psychiatrist, and they could turn themselves around, it was past the 60-day period.
Okay.
These are situations where you want to work with an attorney to help you navigate and help you guide on what's the best path forward. It may be possible, not guaranteed, but it may be possible to request USCIS to excuse the delay. But again, it's not guaranteed. It is not 100% sure that that would be applicable. While that application is pending, please remember that if that application is denied, your unlawful presence clock starts from the end of your grace period, and that timeline can keep running. If you go more than 180 days, you could be barred for up to 3 years. If you go past a year, you could be barred from coming back to the US for 10 years. So, this is not a deadline you want to take
Yeah.
lightly.
Absolutely. That's all right. And Poonam, we do have a lot of questions from our viewers. So I think let's take up those questions.
Sure.
So new viewers have also joined us. Sheikh Bhaskar. Hi guys, thank you so much for your question. Okay, let me go ahead with Bhaskar's question first. Bhaskar is asking, I am in the process of applying for a green card with my I-140 approved. So how does losing my job affect my green card application and what steps should I take to maintain my eligibility?
There are um, lot of nuances here, Bhaskar. What status you're in? Are you an H-1B? Are you, when was the I-140 approved? When you're saying you're in the process of a green card, where in the process are you? Is it, are you at the stage where the perm is being, like here you have a previous, I mean, it could be a previous I-140 that was approved, and you have another green card application with a new employer. Um, so there's a lot of facts here that I would need before I can advise. So I need a lot more information. This is not enough. So maybe we can move to another question.
Sure, we can. And Bhaskar, I hope you're watching our sessions. If you're watching, then please provide us the details because that will be easier for our attorney to answer your question. Go ahead, and we are here for another half an hour, so no need to worry. Go ahead, post your question and bring some more details. That will be easier for us. Okay, Sheikh is here. So, hi, Sheikh. Thank you so much for your question. If I switch to a B2 tourist visa to extend my stay while job hunting, then what are the implications? Can I later transition back to an H1B if I secure employment, or would I need to leave the USA?
A lot of facts again, Sheikh. So I'm assuming you're on H1B status. Do you have a spouse that is on a work visa themselves? If yes, what is that? Do you have a valid visa in your passport? Do you have an I-140 that's approved? That will determine what status you can switch to. If you have an I-140 approved, then switching to B2 is not advisable. And for a multitude of reasons. Given the number of questions, I'll refrain from going into those details, but I'll just do a high level overview. If you find another job within your grace period, then you can start working for that new employer as soon as they file the H-1B. If they file the H-1B for you after the grace period ends, then you proactively should be filing to change your status to another status or leaving the US so that you don't accrue unlawful presence. Once so supposing you choose to leave the US, once the H-1B petition is approved, then if you have a valid visa, all you need is take that approval notice and the valid visa and come back into the US. But if you don't have a valid visa, then you would need to apply for a visa as well. If you switch to another status and before you can switch back to H-1B, that change of status would have to be approved as well. So there is a chain of events that has to happen before you can come back to H-1B. And it's very specific to what happens when to trigger what. So it's a triage, and if this happens, then these are the options. If that happens, then these are the other two options, and so on. So depending on the facts, depending on your situation, you can transition back to an H-1B, but what happens in the intervening period when the H-1B is filed and whether or not you would need to leave the US will be dependent on those facts.
All right. So I hope, Sheikh, you have got so many options over here. And do let us know about your status and some other details as well that Poonam has asked for. And that will be little specific for us to answer you. Until the time, Sheikh and Bhaskar, I hope you have subscribed to Immigration Talk Show. If you haven't, then do it right now. Okay, let me go ahead with the Ricky question. So, hi Ricky, thank you so much for your question. Hello, if I change my residential address through my USCIS account, is that enough or do I still need to fill an AR11 form? The USCIS account does not show an address under my profile setting. For the first time, H1B visa stamping,
Oh,
I
it's
have.
a different
Yeah,
question.
sorry. Okay.
Sorry. So let me
Let's
just answer the AR11 question
sure.
first. Um, I believe, and I'm not 100% sure because my USCIS account is different than yours, Ricky. Filing an AR11 is the best way to change your address on with USCIS because then you have proof. You get an acknowledgement this was filed and submitted. If there is another way to file this change of status through your USCIS account, as long as you have proof of having done that change, that should be fine. Whether it is the filing of AR11 or not, that is unique to the account type of account you have with USCIS. But the critical piece is that you need to have proof of having filed a change of status, change of address with USCIS.
Okay, I think that's important. Yeah. Okay, Ricky, thank you so much for your comment, and I hope you got your answer. Well, Ricky has Poonam a lot of questions. I can see 4 questions have been posted from Ricky. So, Ricky,
Let's
stay.
take some. Let's take from someone else as well, and then we can come
Yeah,
back to.
that's what I was about to say. Okay, let's take from Ailey. And hi, Ailey. Ailey is saying that my spouse is currently on an H1B visa and I'm considering switching to an H4 visa. So, what is the process for this transition and how long does it typically take? Also, can I apply for an H4 EAD to continue working?
So switching from H1B to H4 is definitely possible, and it's a simple form that you complete online yourself. You don't need an attorney for that. It's the form 539.
Mhm.
And how long it takes depends on the resources the government can allocate to adjudicating them. It can take 6 months, it can take a year. There is no time frame that I can give you. USCIS website
Mhm.
has timeframes that are unreliable in my view. I have not found them to be reliable recently, but you can definitely try to track. I would assume for at least a 6 month processing time. And then as for applying for H4 EAD, that is dependent on whether or not your husband or your spouse has an I-140 approval. If they do, then you're eligible for the H4 EAD. If they don't, then you do not. Then you can switch to the status, but you would not be able to work. So you
Okay,
have to take that into consideration and assess all your options and then strategize on what's the best path forward.
that's right. Okay, Ailey, thank you so much for your question, and I hope you got your answer. Go ahead and put another follow up question or anything that is in your mind, and we will definitely take that up. Okay, so Poonam, as you said, let's come back to our questions because those are also very important for our viewers to understand. Now, okay, let me pick up with the most favorite question that I have for you. That is, does someone need an attorney to file a change of status? What do you want to say on that?
It depends on your situation. If you are filing to be a dependent on your spouse's visa, then and it's a straightforward petition, then you don't need an attorney. You can file it yourself. But if there are any doubts, if there are complications, if you don't understand your options,
Mhm.
then it is always better to go with an attorney. It may be possible to have a consultation with an attorney, identify what your options are, and then if it is something straightforward, then you can file it yourself by all means. But first assess. I had a client come to me
Mhm.
for a consultation, said, I just need to confirm that this I can switch to the date I need to switch to the B2 status. I was laid off on H1B. I just need to switch to B2 and I just need to confirm the date.
Mhm.
And that person did not give me any other information, and this was the sum total of the information. I said, sure. We get on the consultation call, we go through the dates, and then they mention, oh, my spouse is on H1B. And
Okay.
I was, I asked them, had they considered switching to H4?
Mhm.
Like, no, I didn't even know I had this option. So sometimes talking to an attorney and explaining, providing all the facts can make all the difference between what strategy makes sense. As I said before, someone with an approved H1B and I-140, a B2 switching to B2 is not the best option for them because a B2 requires non-immigrant intent, but an I-140 approval indicates immigrant intent, and there is a possibility of
Mhm.
that B2 getting denied, which would create more hassle and more headache than strategizing upfront on what the best options are. So that's my recommendation. Yes, it may cost you a little bit of money upfront to go consult with an attorney, but that small fee may save you a lot of headache down the road.
Perfectly, perfectly mentioned. Yeah. And that was such an honest answer, Poonam. Thank you so much for putting up that. And
Oh,
I would also suggest, friends, that it's really high time right now. So go ahead and why don't you contact Attorney Poonam Gupta? You just have to visit this link that is on your screen and you will get the contact details of her. So I think that's the best thing you can do right now. Consult with an attorney, have expert guidance, and get this opportunity and do what is best for you. Okay, and with that, there's another question, Poonam, that what are the top three smartest steps that every laid off H1B should take immediately to stay protected?
first, identify what grace period, if any, you have. If you don't have any grace period, then that determines a lot of things. But if you do have a grace period, then figure out what are your options. Can you get, um, can you find a new employer within that grace period who will file a new work petition for you? What are the visa categories you can switch to? A lot of people are dual nationals and may be eligible for multiple visa categories. Um, and I've had situations where someone's on H1B, they've lost their job, and they're thinking about what to do. And this was an actual case where this person is all in panic, and it's like, I have nothing to say. Okay, you can switch to a dependent status. Like, yes, but my spouse is a US citizen. I'm like, okay, take a step back. You're married to a US citizen. You can apply for your green card through that. But people are so focused sometimes on their immediate aspect that they forget that there are lots of options outside of H1B. They could apply for O1, they could apply for H4, they could apply for F1 if needed. But there are options that you need to consider before panicking. Keeping a calm head and exploring the different options are the most critical aspect.
That's right. Okay, so I hope that these smartest steps will be helpful for you guys. And make a note of all these pointers because these pointers are, you're not going to get anywhere, but here in the show, you're getting these pointers. And these are very important. With that, I think let's move ahead with my next question also. And that is how can one strategically use this grace period to stay in the US legally?
The first piece is, as I've mentioned, figure out what is the timeline for the grace period, and then start from there.
Okay.
What are your next steps? Are you what status is the best option for you to switch to? Is moving back to your home country an option? And continuing your job search from your home country the best option? This may be an opportunity for you to go back to your home country and spend time with your family without the stressor of managing your finances and managing a lease without any income coming in. It is an option, and like there are companies that have remote roles that, and most employers interview over Zoom.
Yeah.
So you could, I've had lots of clients who've gone back home and decided that was the best move. They tried for their 60 days. They didn't get a job. They moved back to their home country, continued with their job search, got a new job, and then came back for their new job. And then they're not restricted to the city they're in. They're not restricted by anything other than the best fit for their skill set. So don't I would say do not rule out moving back to your home country as an option either. As much as you want to stay here, sometimes taking a step back and reassessing your options can change a lot of things.
That's right. That's wonderful. With that, there are lots of beautiful messages also, Poonam, that you're sharing with us, and really feels so good. Okay, so this is a question that we got in our WhatsApp group, and Rahul is here. So, hi, Rahul. Thank you so much for your question. He's asking that, hi, I'm interested in starting my own business. So, is it feasible to establish a company and have it sponsor my H1B visa within the 60-day grace period? What are the legal considerations and challenges involved in this process?
Hi, Rahul. Thanks for that question. We could speak for an hour on that topic alone. But the short answer is yes, it is possible now for anyone to establish a company and have that company sponsor the H1B. Whether it'll be practical within the 60-day grace period, I'm not sure. Just given all the things, the pieces of the puzzle that need to be put in place before that can go through, but legally it is possible. One way to sort of be prepared is to have the entity, the corporate entity, set up ahead of time. Anyone from anywhere in the world can set up a company in the US. There is no requirement that you need to be physically in the US to set up a company. So, my recommendation would be to plan for the worst and, uh, expect the worst and be prepared for it. And then, so that if there is a need, you can pivot to having that company sponsor your H1B during the grace period. Well, one other way is if you are in H1B already, you could have your company sponsor you for a concurrent H1B simultaneous to your full time job. Concurrent H1B is an option, whether it is with cap subject or cap exempt, depends on your situation, but it is possible. Then, if you are concurrently employed by two employers, one of which is your own company, then if you are let go from one company, you can continue working for your company and not have to worry about the 60-day grace period. And if you find another job, then you can continue. That company can file for your H1B at any time, and you would not have to be worried about the 60-day grace period. The one note of caution that does not get talked about self sponsorship for H1B is that while H1B sponsorship is possible on your own company, green card sponsorship is not a possibility with this option. So, again, it is not a short term vision that you need to have, but you need to look at the long game, not just the short game. It's not just about what you need right now, but what you may need 5 years, 10 years, 15 years down the road as well. So just be mindful of that. But in short, yes, it is possible to have your own startup sponsor you for H1B.
All right. That's great. And Rahul, I think that's a good news. So go ahead and do the possibilities and let us know also where you're talking us from. And we would love to have more knowledge for you from you. Okay, let me go ahead with Alicia. Alicia is also here. So hi, Alicia. Hi, Poonam. I was laid off from my H1B position 2 weeks ago. So could you clarify when exactly the 60-day grace period starts? You
Sure.
have answered, but yeah, I think let's
Correct.
continue.
So, Alicia, the first thing to look at is when does your I-94 expire? If it is more than 60 days from when you were laid off, then you have the full 60 days. If it is less, then your grace period is whenever your I-94 expires. And if assuming you have the full 60-day grace period, then when you say you were laid off from your position 2 weeks ago, I assume you mean you stopped working for that company 2 weeks ago, and the last paycheck you received listed that date from 2 weeks ago as your last date with the company. If that is the case, then your 60-day grace period starts from the next day after that. And you need to be mindful of that timeline. But again, if any of the facts change, that calculation will change.
Yeah, absolutely. Okay, and there's another follow-up question from Alicia. Is it from the date of termination, the last page? Okay, or the end of severance period? Okay, this is the same question. So I hope, Alicia, you got your answer and stay connected, stay tuned with us, and also don't forget to like, share, and subscribe to Immigration Talk Show. With that, Poonam, we have just 4 to 5 minutes left, and I really want to cover more questions, but we do have a lot of viewers in Facebook group as well. So, with your permission, can we take like two or three questions from
Yeah, of
Facebook?
course. We can stay for another 10 minutes.
Okay, that's so sweet of you. Okay,
Sure.
so control, please share the screen. Okay. So
So,
this is a
how
question that
long?
we got from Walid. Okay, yeah, let me read it out. Walid is asking how long it takes to get a decision from USCIS for change of status for spouse on E2 category. So Poonam, this is not actually our topic's question. These are the random questions that we are taking
That's
from people.
fine. I mean, someone can apply, could be an H-1B status and could apply for change of status to E2 as well. And it is, the timeline could be, as I mentioned, it's the same as for H4 or any other change of status or P2. It could take 6 months, it could take 2 months, it could take a year. There is no set timeline. The government's priorities change constantly, and the resources they allocate to adjudicating these petitions change consistently. So I would budget for at least a 6 month wait time.
All right. Okay, so Walid has got his answer, and let's move ahead with our next question. Okay, so the question is my PD is 29 June 2023 on EB3 skilled on all chargeability areas category. So when does my PD will be current following the trends? What do you have to say, Poonam?
I have no idea what um, the first clarification I will say is that there are no trends for the priority date. As much as someone is able to predict using AI and data analytics, then I would love to see that tool as well because it is a calculation that the Department of State makes on a monthly basis and then publishes in the visa bulletin. I just looked up the visa bulletin. Currently, the category in which you are in, it is at, for June of 2025, the priority date is at February 2023. You are in June 2023, it could take 6 months, it could take 3 years. I hope it will not take 3 years, but there is no guarantee that it will not take more. The date does not move month to month, and it doesn't move consistently from one month to the other. So it's not like the priority date moves 1 week every month or 1 month every month. It
Yeah.
may move 1 week, it may move 5 weeks, or it may move backwards 3 weeks or 2 weeks or whatever, depending on what the need and the priorities are and how many applications are ahead of you with the priority date you have. So it's all dependent on how many people are in front of you and how many people file and get approved in a given month that will dictate.
All
whether
right.
or not your priority date becomes current.
All
And
right.
Sam, I believe Ricky had a bunch of questions. Maybe we can take some of those as well.
Sure. I think this will be the last question from Facebook, and after that, we can shift
Sure.
to Ricky's question. Okay. The question is: anyone here from Philippines who applied AB3 unskilled and their priority date is current? Okay. So this is something we can't take because. Okay, I think this is a very random question. Can we take another question that we got from Ricky? Because I can see Ricky has posted four questions together. Okay, let's take the first one. So Ricky is saying, thanks, my I-140 form has been pending for the last 7 months. Can I file premium processing for it at this stage? And you suggest it? Also, can premium processing increase changes of RFEs?
Ricky, it depends on what is the basis for your I-140. If it is based on a perm, then I don't think there is any risk with filing for premium processing. Uh, and again, it depends on whether you your priority date is current or not. If your priority date is current, then it may be worth, you know, asking for an expedite through premium processing. If it is not, then the longer it stays pending, it doesn't really change anything for you other than uh, some factors, potentially your spouse's ability to work. Once the I-140 is approved, your spouse has the ability to work. While it remains pending, they obviously cannot work. If your I-140 is not based on perm, but say it is an NIW petition or an EB1 petition, then I think it's a balancing act on whether it makes sense to file a request for premium processing, because sometimes that can trigger an RFE and additional scrutiny. So, this is a strategy that you need to discuss with your attorney who has your file, who has the ability to assess all your facts and your entire situation and guide you on what is the best path forward. But it is possible to do so. And in some cases, it may invite additional scrutiny, but not always.
All right. Okay. And let me take up the next question that we got from Ricky. Hello, my
It's
Ivan
the,
40.
it's the same question.
Oh, yeah, I'm so sorry. Okay. Yeah, I think he posted both the
The
questions
same question twice.
twice. Yeah. Okay. And this also we have taken the address one. For the first time, H1B visa stamping, I have heard it is suggested to get stamping done from the home country, which is India in my case. So, do you suggest the same or can I get it done from Europe?
You heard correct, Ricky. It is preferable to do the H-1B stamping from your home country, and I would highly recommend it. When you process your H-1B in your home country, there is a level of comfort, um, because the consular officers in that country are aware of the conditions and some of the local conditions that may be obvious to someone in India but may not be obvious to someone in Europe. And I will tell you this, given the situation globally, most consulates do not look favorably upon individuals who do not process their visas in their home country. If there is a reason why you need to process in Europe, um, then you need to articulate that to the consulate, whichever consulate you are going to apply to. You need to get their permission and approval before applying there. If you go and book an appointment in any consulate in Europe without first getting their approval, there is a chance, and a very high chance, that you complete everything, you go through the process, and a few days before your appointment is canceled because the consulate cannot process third country nationals. So, to avoid all the stress, going back to India to process your H1B is the best way. So, I would highly recommend doing that.
All right. So, Ricky, come to India, and India is a beautiful country. You will really enjoy that. Okay, and with that, Poonam, we have covered so many questions. I'm really amazed to see, we have actually covered more than 20 questions. So this is a great thing. I'm really, so happy with these things. And friends, the best part is you can also get in touch with Attorney Poonam Gupta on the link that is shown on the screen. Go ahead, ask questions, and you'll get the contact details of her. And with that, it's almost more than an hour. And it was really a great session, lots of insights, wonderful messages. So thank you so much, Poonam, for having such a great comeback to Immigration Talk Show. We really enjoyed this session and hoping to see you soon.
Likewise, thank you for having me, and thank you all for your great questions. It's great to be have such an engaging audience. So, thank you for your questions and stay connected. Thanks, Sam.
Thank you, Poonam. Have a great day.
You as well. Bye.
Okay. All right. So, friends, that's all for today's episode. I hope you liked watching this webinar. Still, any questions? Though we have already got a lot of questions, but still, if you have any, go ahead, post them on the comment section. In the next episode that we are going to have with Attorney Poonam Gupta, we are surely going to take those questions. So till then, don't forget to like, share, and subscribe to Immigration Talk Show if you want to keep yourself updated and stay informed regarding all the information that is happening in the world of immigration. I would recommend and suggest Immigration Talk Show will be the best option for you. So hit the bell icon also to get the notification whenever we come up live with these amazing webinars. Till then, thank you so much, everyone, for joining us. Have a great day, and thank you so much for watching Immigration Talk Show. See you next time.